The Supreme Court of the United States simply indicated that the age of assault weapon bans is coming to an end, following years of watching from the sidelines as lower courts openly violated their precedents. The justices have finally stepped in. This is not only another legal update, it is the beginning of a constitutional earthquake that could dismantle every AR-15 and semi-automatic firearm prohibition throughout the country overnight. Should you live in California, Illinois, New York, or any of the 10 states at the moment making the most widely used firearm illegal, and you must pay close attention, America. Pay attention. On the 8th of November, the Supreme Court granted certiorari to Snope versus Brown, combining it with difficulties from Maryland and Illinois that have been languishing in the petition pile for more than 18 months. This wasn't just any choice. The court purposefully chose instances that exhibit the most pristine constitutional issues with the most extreme circuit splits. And what follows will redefine the second a century-long amendment. Subscribe right now and press the warning bell, since the mainstream, the media, mostly ignores the particular legal actions taking place in Washington, D.C. right now. Additionally, these actions are the secret to retaining and bearing arms. Right now, we are witnessing a national crisis of outlawed guns. As we sit here today, over 100 million Americans, over one-third of the population, living in constitution-free areas where having a standard A firearm that is semi-automatic can put you in 10 years in a federal prison. We aren't talking about weapons of war or unusual military equipment. We're talking about the AR-15 platform. Rifles are so widespread that there are more of them in civilian hands than there are Ford F-150s on American roadways. There are roughly 24 million of these weapons in circulation, giving them the #1 selling rifles legally in 41 and in America among the 50 states. However, states such as Maryland, Hawaii, and New Jersey have passed laws that forbid more than 200 particular models by name. The State of Maryland Firearms Safety Act outlawed 45 specific rifle models and barred any copycat weaponry that collaborate on their operational characteristics. In California, that number exceeds 300 when you factor in every variation. Illinois passed the Protect Illinois Communities Act following the shooting in Highland Park, making semi-automatic weapons illegal with detachable periodicals in any of a number of other features. These states have restricted more than just firearms. They have sought to delete an entire type of technology in the possession of law-abiding people. How did we arrive at here? For many years, the Supreme Court produced important verdicts like Hella and Bruin, proving that the government cannot outlaw commonly used firearms for legitimate reasons. But instead of under the law, lower circuit courts participated in the activities that Justice Clarence Bruin evasion has been referred to by Thomas. In the 4th, 6th, and in the 9th circuits are virtually disappeared, Rouge creating tests that aren't in the Constitution to justify preserving these bans in place. After the Supreme Court decided Heller in 2008, establishing that the Second Amendment defends a person's right to bear arms, lower courts encountered an issue. How do you uphold popular gun control laws when the Constitution states that won't be violated? They received imaginative. Federal appellate courts invented the two-step strategy that the Supreme Court never permitted. Step 1 inquired as to whether the controlled weapon falls within the scope of Second Amendment protection. Step 2 applied intermediate examination, weighing government interests at odds with those of individuals' rights. This structure made it possible for judges to respect the rights of the Second Amendment exist, while upholding nearly any limitation that they personally preferred. The Fourth Circuit pioneered what they referred to as the military features test. If a firearm has traits in common with military weaponry, courts can exclude it from constitutional safeguards based on its design as opposed to its typical application. In the most recent instance of Snoke versus Brown, some went so far as to say that AR-15s are military-style weaponry meant for prolonged fighting, utterly disregarding the fact that they are utilized millions of times a year for hunting, sport shooting, and above all, at home defense. The Seventh Circuit went. Additionally, the decision in Friedman versus due to the fact that AR-15s are more dangerous than other weapons, states can ban them even if they're commonly owned. Go over that reasoning cautiously. The more popular a firearm grows, the more hazardous courts declare it, which somehow excuses prohibiting it despite its widespread use. It's constitutional logic that consumes itself. Courts cited 19th century laws to support the prohibition of Bowie knives, contemporary guns. Notwithstanding, those regulations controlled how people carried guns in public, not if people might possess whole classes of weapons. The Ninth Circuit even upheld California's ban by quoting ancient English statutes restricting crossbows among the peasantry. The 14th century law disarming English commoners became the justification for disarming Americans in the 21st century. This was the breaking point. The Supreme Court observed this judicial insurrection for 3 years and witnessed the ridiculousness reach a level that the highest court in the land could no longer ignore. Next, Bruin happened in 2022, and the Supreme Court dismantled the entire structure. Justice Thomas suggested that if the second the plain wording of the amendment addresses the conduct at question, the Constitution presumptively safeguards that conduct, and the government must demonstrate that its regulation is in line with the nation's historical legacy of firearm regulation. Interest balancing is no longer necessary. No more intermediary scrutiny, text, history, and tradition exclusively. Lower. The courts ought to have declared assault illegal, prohibitions on weapons right away. But here's what they did instead that forced the Supreme Court's hand. After Bruin came down, gun rights activists expected lower courts to declare legislation unconstitutional meet the requirements of the historical tradition test. Instead, federal judges engaged in what can only be characterized as constitutional resistance. The Fourth Circuit reheard case post-Bruin and issued a ruling that explicitly accepted the Supreme Court's methodology was unworkable and shouldn't relate to prohibitions on assault weapons. That's a federal judge declared that the Supreme Court precedent is uncomfortable. Thus, he is not paying attention to it. District of Illinois courts acknowledged that AR-15s meet Heller's common use standard with 24 million in circulation, then ruled they could be banned anyhow based on their possibility of abuse. The justification falls immediately under investigation. The possibility of abuse would support prohibiting cars, which cause 40,000 deaths Americans yearly, or alcohol, which contributes to 95,000 fatalities yearly. 23 federal judges have now made decisions Bruin's support for assault weapons forbids utilizing reasoning that directly defies the Supreme Court's mandate. That's not a few rogue judges misinterpreting the precedent. It's systematic defiance of constitutional authority. Currently, 9 circuits have commented on the prohibition of assault weapons, with 3 striking and 6 upholding them down. That circuit split made intervention by the Supreme Court is unavoidable. But timing counts, and the court's choice to award certification now instead of waiting for another term to indicate anything critical. The majority of conservatives isn't merely irritated with the lower court defiance no longer. They're ready to reaffirm constitutional power using a decision that will be binding on all states and nationwide federal court. The highest the court did not select a single case, randomly. Brett Kavanaugh, justice joined by the court's conservative majority, has basically outlined the roadmap. They are waiting for the perfect vehicle, a case that doesn't merely contest a tiny portion of a law, but immediately targets the jugular of the complete assault weapon tale. The court is no longer only looking for a justification for avoiding the altercation. They're searching for the ideal time to deliver a clean ruling, one that doesn't only strike down one statute in one state, but establishes a national norm that prohibits any state from ever outlawing a semi-automatic rifle based on its cosmetic features again. But what would the day after such a verdict look like? And more importantly, what does the data genuinely state regarding these guns that may demolish the government's entire case? While the media yells about war weapons, the real information that the Supreme Court is now examining tells a very different story. The complete defense of assault weapons bans are based on a straightforward assertion. These rifles are particularly hazardous weapons of the war accountable for mass casualty events, and banning them will save lives. That assertion is not sustained. Interaction with real data. The FBI's uniform crime reporting data for 2022 demonstrates that firearms of all kinds, such as hunting rifles, AR-15s, and every other rifle category combined, were employed in 456 homicides. Handguns were utilized in 8,029 killings that same year. That's 17 times as many homicides with handguns compared to rifle killings. Knives were employed to murder 1,630 people, more than 3 times the number the rifle total. Blunt objects like 521 individuals were killed by hammers. Human hands, 749 persons were murdered by feet, 64% more than all rifles combined. If assault. The most hazardous thing is weaponry, threat that justifies banning them. Why do they account for a tiny fraction of killings as opposed to weapons that no one owns, suggesting a ban? The FBI's active statistics on shooters from 2000 to 2023 show that handguns were used in 62% many occurrences, but any kind of firearm showed up in just 31% of cases. States that assault weapon bans don't indicate reduced homicide rates in comparison to those in states without them. California has continued to extensive prohibitions since 1989 and saw an increase in mass shootings casualty rates from 2019 to 2023 than Texas, which has no such constraints. The relationship between assault weapons prohibitions and public safety is non-existent. The myth that these guns are the major drivers of violence is an empirical falsehood. The Supreme Court's The Bruin ruling mandates that legislation be in keeping with custom and history, not fear and theater. When the justices examine these figures, the government's compelling interest argument begins to disappear. The information makes the situation unsolvable for states in favor of banning assault weapons. They have to persuade the Supreme Court that firearms utilized tens of thousands of defensive times a year are too risky for citizens to possess, while providing an explanation rifles that killed 456 people annually defend the ban, while handguns blamed for 8,029 deaths remain lawful. However, something embroiled in the ongoing legal dispute that may put an end to this argument forever. The Insnope versus Brown, the petitioner's brief presents a case that goes well beyond if many people own AR-15s. The Supreme Court is being asked to determine that weapons appropriate for the strongest use of militia's constitutional safeguards, not the weakest. This changes the entire framework the lower courts employ to support prohibitions. Historically, anti-gun campaigners contended that if a weapon has a pistol grip, a threaded barrel, or collapsible stock, it is too military for civilian use. However, according to recent filings, legal experts are referring to a case from the Supreme Court United States versus Miller, 1939. In fact, the court determined in Miller that a weapon needs to be protected in order to have some reasonable relationship to the maintenance or effectiveness of a well-regulated militia. In other words, the protection of the Second Amendment is at its strongest for weapons that have military utility rather than its weakest. The brief records that private individuals at the founding possessed weapons of military quality as a matter of course. The Pennsylvania long rifle was the most advanced military weapon of the time, and citizens owned them freely. Individual. The same muskets that were used by soldiers from the Continental Army. Cannons as well as artillery pieces were privately owned. The Militia Acts of 1792 required able-bodied men to own military weapons as well as ammo. Congress didn't just allow civilians to own military equipment arms, they made it mandatory. By labeling the AR-15 as a war weapon, according to states like Maryland and Illinois have unintentionally entered a constitutional trap. Should they acknowledge that the AR-15 is a military-grade weapon, they are basically acknowledging it is exactly the kind of arm the Second Amendment was aimed to safeguard. Should they assert that it is not a weapon used in combat, their whole hazardous and peculiar the case against it is disproved. It's a checkmate moment that the Supreme Court is apparently eager to address. This argument places state attorneys in a difficult situation. If they recognize that AR-15s aren't truly military weapons, they lose the dangerousness reason that justifies banning them. Should they acknowledge that AR-15s are military appropriate, then they are exactly what the Second Amendments provide protection. The reply briefs attempt to avoid this snare by stating AR-15s are military style but not appropriate for the military, a distinction without a distinction that runs counter to itself. 82% of the nation treats a product as a typical legal instrument. That tool is by definition in common use. By prohibiting them, the other 9 states are not controlling weapons. They're acting as outliers that are violating the national norm. Justice Kavanaugh stated in a recent statement that it is analytically difficult to differentiate between a semi-automatic rifle and the court's semi-automatic handguns already protected in Heller. This is the buried in the present is the nuclear option. Litigation that the majority of people do not see. States that oppose guns have long maintained that although a weapon could be shielded, the magazine is only an attachment that can be limited to no more than 10 rounds. In 2026, instances such as Duncan v. Rhode Island's difficulties in California. The island is at the height of its fever. The Supreme Court is currently debating an argument that will end this discussion once and for all. Without an arm, it is useless. It's feeding apparatus. If the court decides that weapons are protected by the Second Amendment with their typical factory-issued setup, then each magazine banned from Washington to New Jersey in the United States overnight, it vanishes. This is the domino effect. If the AR-15 is protected, then it was the typical 30-round magazine, intended for usage as safeguarded. If the Glock 17 is protected, then the 17-round it comes with a shielded magazine. This would effectively restore the 100 million Americans' rights to possess contemporary self-defense gear without fear of being charged with a criminal for a piece of plastic and a spring. If the Supreme Court strikes down assault weapon bans as being against the Constitution, the urgent legal, there will be enormous repercussions. Every state prohibition is rendered unenforceable overnight. New York, California, and New Jersey, Maryland, Illinois, Connecticut, Delaware, Hawaii, Massachusetts, and Washington is unable to uphold laws that the Supreme Court declares unconstitutional. The laws become legal nullities. Millions of Americans living in prohibited states restore the constitutionally guaranteed right to purchase and possess semi-automatic weapons that are forbidden for decades. These states' gun shops will start stocking AR-15s right away and other firearms that were previously prohibited. The economic impact will be measured in billions when manufacturers transfer inventory to newly created markets representing over 100 million prospective clients. What regarding the persons currently in prison or being prosecuted for having a prohibited rifle? A decision of the Supreme Court on this magnitude generates a huge legal wave of possible pardons and appeals, as you cannot be held for a crime that is not a crime, according to the Constitution. This is more than just a victory for gun owners. It is a restoration of the constitutional administration. Don't be tricked. The states that oppose guns are already getting ready. Their post-decision approach, just as we saw after Bruin, when states replied by proclaiming every square inch of their territory a sensitive place. We anticipate states to try and install big taxes, requirements for liability insurance, or difficult-to-pass training mandates. But the 2026 Supreme Court is different. The Bruin evasion has been witnessed by them. Methods and the forthcoming ruling is likely to contain anti-evasion simple enough language that even the most lower court activist judge won't be able to interpret their way around it. Oral April is when the arguments are planned. At that point, we'll observe how the justices are considering these inquiries. Listen for how they handle the military dispute about weaponry. Watch whether they acknowledge the standard of widespread use as dispositive. The government's brief is due in February when the decision drops, probably around late June. The legal America's gun rights environment will change overnight. We are standing on the brink of the biggest growth of Americans' rights under the Second Amendment history. The phrase ban on assault weapons, composed of politicians rather than engineers, is nearing the end of its legal life. This is the reason you should pay attention. Subscribe immediately in order to remain ahead of the curve. I'll be dissecting the oral arguments as they happen and providing a thorough dive into the final judgment as soon as it is released. There is discussion about your rights in Washington at the moment. Avoid becoming the last to find out the verdict.